Good morning, Mr. Merriman.
Good morning.
Thank you.
May it please the court, there's 5 issues that are raised in my brief. If I could, given the length of time that I'm permitted, really just focus on the first 3 issues. I trust that the
Mr.
court...
Nyman, I just have to tell you, you are the only one of the 4 cases that we are hearing this today, which was within the page limit. So congratulations.
Commonwealth.
And the Commonwealth, that's true.
Hopefully I'm off to a good start then. The first issue I'd like to focus on is the improper limitation of trial counsel's cross-examination of a really, in my opinion, critical witness for the prosecution. There was a woman by the name of Nellie Correa who was braiding hair for money in a parking lot adjacent to a liquor store, which is right where the crime occurred. Trial counsel worked very hard to establish through this witness that much less time passed from the time that she started braiding Mr. Velasquez, the victim's hair, until the defendant fired the fatal shot.
Could I ask you just, I just want to be clear, and I probably should let you finish, but the title of that argument suggests that the reason that timing is important was for self-defense, but the text is really about deliberate premeditation. Is it the latter that you're really pressing here?
It's only deliberate premeditation.
Okay.
I apologize if that was somewhat confusing.
Okay, but it's deliberate premeditation that you're on.
It's absolutely deliberate premeditation. There are several photographs that hopefully this court will have an opportunity to review. One of them is exhibit number 12. The other 2 are B and C for identification. And you might be asking, why wasn't B and C offered as a trial exhibit by defense counsel? I think it's probably pretty clear from reading the transcript. I would speculate, but I think I'm pretty safe in doing so, that that was a strategic decision that he made because those were relatively gruesome photographs, at least according to the trial judge, and he probably didn't want the jury to see those. Those were autopsy photographs. But what's really critical here is that he was not given the opportunity to prove through cross-examine, or certainly challenge the credibility of this witness through cross-examine, by referencing these photographs. And the Commonwealth in its brief makes the point that, as the judge made, well, the witness had already testified that she had done 2 braids and was starting the 3rd braid, and that it would be sufficient for trial counsel just to get the information by asking her questions rather than presenting her with these photographs. But it wasn't, because the photographs, to a large extent, contradict what she was saying. And her testimony might have been smooth.
In what way? Did they show less braid? Did they really show the full hair so you can see how many braids were done? And
They do show less braid, and plus you have to consider one other fact. Ms. Correa made the comment, no, I didn't do that braid, when she was referring to one of the braids on exhibit number 12. And that was something that was
so you could see the full head of hair, so you could see all of the hair and where the braids were and where they weren't.
You can see it if you look at all the photographs in conjunction with one another. You really can't tell from looking at one photograph because it's sides of the head, and then other ones are, the other pictures are compromised by the work of the medical examiner.
Now, if you assume the judge would have given full leeway, or should have given full leeway, what could have been argued in closing different from what was argued in this case? What's the best that you could have gotten from a full cross-examination on this issue?
That 15 minutes didn't pass. That much
Okay,
less
so
time passed.
Much
Perhaps
less
it was a
time,
matter of
meaning 10, 5?
maybe 1, maybe less than 1. And the point is, I understand that the law says that in a split second or less than a second, someone can form deliberate premeditation. But that's for the jury to decide. And 15 minutes of leaving and arguably having time to cool down Yet coming back, retrieving a gun, and shooting somebody is much more clear and convincing evidence of someone's mental state, that in this case that he deliberately premeditated, than 1 minute where the person leaves.
But if the testifying witness said that I don't even recognize this man from the picture, and so much could have happened during an autopsy to disturb us here.
I'm not really sure that's exactly what she was saying. I know what you're referring to in the transcript. I know what you're referring to in the Commonwealth's brief, and to some extent in my brief. When you read her testimony, she was much more cooperative with the Commonwealth during direct examination than she was with defense counsel during cross-examination. She seemed to be somewhat argumentative. Perhaps it was just the style of cross-examination, given that the defense attorney who was examining her. I'm not really sure. I know he has an excellent style. It's considered somewhat aggressive by many people, arguably sarcastic at points, and maybe she wasn't taking it very well. Nevertheless, she wasn't as cooperative when he was asking her these questions.
So the nature of the questions, because I haven't read the transcript, is what? You show Exhibit B, do you recognize this work? Do you recognize this person? Is that the question?
Yeah, in essence, yes.
It's essentially saying, you said you did 2 blades. This one is, what did you, I mean...
And probably more to the point, how long did it take? She said that it would take her 10 minutes to do the entire head, but 15 minutes had passed, and there were a limited amount of braids on the head. If one of the braids was already there, because she said she didn't do that, then there's even less braids that she had to do, and much less time passes.
So these are not in evidence, you're saying?
Well,
so how can they be used? To refresh your recollection? Does this refresh your recollection as to how many braids? Is that how they were used?
Absolutely.
Okay.
And they were marked, so they are part of the record, certainly for the court to review in considering whether...
What's not clear to me is, I haven't seen the photographs. It was obviously the judge was concerned about them. I'll take your influence that trial counsel tactically didn't want to get B and C in because they were gruesome. I mean, so trial counsel must have known, that there was some risk in proceeding. It's almost as if the judge is saying, you're just trying to upset. In fact, she did say you're trying to upset the witness.
Well, it is essentially what she was saying, or at least in part what she was saying.
She, as I read through that part of the transcript, at least the part that you have, it's as if she doesn't understand the argument that defense counsel is making.
Right, and she's focusing on, well, she admits that she braided the hair. We're not taking issue with the fact that, and that wasn't what he was getting at. He tried to make his point. Just from a reading of the transcript, obviously I didn't witness the trial, but she was pretty tough with this defense attorney at various stages of the trial for whatever reason. And perhaps she had some issues again about his style, but I certainly find it very effective. In many other cases, he gets an awful lot of good results, and he's certainly a well-respected, hard-working defense lawyer. Unless the court has any more questions on that issue, I'd like to focus on the second issue that I raised in the brief, and that one pertains to the judge's refusal to give an instruction on self-defense.
How could this be self-defense, even if you accept the statements offered by the doctor as part of the psychological defense?
Well, I think what you probably have to do, and I'm not sure if, hopefully I articulated it well enough in my brief, but I think you have to focus on the testimony from December 15th of 2005, pages 158 through 160, where the doctor testifies about the stories that the defendant gives him. And there's a couple things that this court should keep in mind when you're looking at that. There was a history there. The victim was known to the defendant as somebody who was extremely aggressive, violent person. He had made threats to the defendant's family, and he was known to carry a gun. There's also some discussion in here about whether or not at some point the victim brandished a gun by picking up his shirt and showing the defendant a gun that he was in possession of at the time, and whether or not that was the gun that the defendant went back to the victim's car and retrieved and shot him with, or whether there was some perception on the defendant's part during the struggle that this person was still armed.
But wasn't the statement to the doctor that he brought the gun and it accidentally went off?
That was, well, there were two stories. That was one of them. The other one, not that
Well,
he brought the gun that he retrieved.
the other one is less helpful to you. I mean, that's the most helpful, right, on the self-defense issue?
Right, but that's why I said if you read it, and it's the transcript and the testimony of the doctor is somewhat muddled, perhaps because of the defendant's mental condition when he was making the statements to the doctor. But that statement, the first one that you just made, Justice Botsford, is somewhat tempered or qualified by additional statements that the defendant made, such that the victim had lifted his shirt and he had seen a gun and the other threats that were made. So I think when you read everything in conjunction, there is this argument that could be made and that was made at one point. I think the trial judge, at least initially, agreed that there is this struggle going on where perhaps there was enough evidence to show or to warrant an instruction on self-defense. If we can address the third
Let me
issue.
ask you, but this was a parking lot. He has to retreat. He has the duty to retreat before you can get a self-defense instruction.
Except I'm not sure to what extent that he was able to retreat given the nature of the struggle at the time. There was some suggestion that the victim was much larger than him.
But he didn't have to go up to the victim. He went back. Wasn't the evidence, if I remember correctly, he went back to his car for whatever reason and for whatever time. He went back to his victim's car for whatever reason and for whatever time. And then he came up there to
Right,
the
but
victim.
And at some point, they end up in this struggle, which is not, it's only clear by or I should say, it's only supported by the defendant's statement to the doctor, because everybody else who was at the scene says there was another story, and that's that the victim was still in the chair, or perhaps arguably getting up from the chair when the defendant brandished the gun. But if you believe the defendant's story, when he comes back, there is some kind of a struggle, which assumes that the victim at that point is out of the chair. There's reference to him being awake.
Do you agree that he came back with a weapon?
Well, I agree that he came back. I mean, according to his statement or according to everybody's statement?
According to his statement.
Yes. I mean, that's
Okay,
what
so
he
why
said.
did he come back with a weapon? He didn't have to.
Well, I mean, there's all different reasons you can come
No,
back.
but I mean,
with a-
how can you get a self-defense instruction when you walk up to somebody with a weapon? I don't follow that.
Well, if you didn't intend to use the weapon, if something happened after brandishing
You
the
walk
weapon.
up to somebody with a weapon, the other person may think that you may intend to use it.
Absolutely, but that is sort of reversing it.
Okay.
And again, then whatever happens during the struggle is somewhat unknown, but I again direct this court's attention to the statement about the victim having a gun in his possession and that being in his waistband. If I can get to the third issue, that being the issue of mental impairment and the adequacy of the instruction. I understand that this instruction mirrored the model instruction. And I think to a large extent that the Commonwealth is relying on that in saying that this was a legitimate instruction. My argument is this. You would never let a layperson come in and testify, yeah, he's mentally impaired, and then be able to argue that to a jury. Mental impairment has more legal significance than just the words mental impairment. And I know that in a couple of cases in the past, this court has considered this issue. I don't think in the context I've raised it, but certainly in dicta said that reference to the jury's ability to consider mental impairment, essentially as outlined by the model jury instruction, is sufficient, and there need be no more definition. I think that's wrong. I really do. I think there should be some sort of definition. You know, we don't talk about self-defense and just say, throw it out there, you can consider the issue of self-defense or accident. We don't talk about insanity and say, You can consider whether or not the person was
Yes, but
insane.
but let's just take self-defense. I mean, the instructions explain what the term means, but here, the only way you're going to get an instruction that uses the terms mental impairment is that somebody, and in this case it was Dr. Ebert, has testified to the details of what he thinks that mental impairment is. So it's not as though the jury has to rely on the judge's use of that phrase by itself. I mean, it is a reference to something that is in evidence.
Sure, but when someone gets up and said, he was coming at me with a gun, so I had no choice but to stab him, I was acting in self-defense, that's the same thing, but you give an instruction on it. You know, all testimony that or evidence that warrants an instruction typically gets an instruction. But this doesn't. Mental impairment doesn't get a defining instruction.
So what would you ask, what would you have the judge do?
Well, to define exactly what mental impairment is,
And repeat Dr. Ebert's testimony?
no, but to tell them how they can consider it in the context of this case, that mental impairment is something that reduces murder from murder in the first degree to murder in the second degree, because it has the effect of precluding somebody from forming deliberate premeditation.
Isn't that part,
No.
that instruction
You
wasn't?
may consider the reference or fact that the defendant may have been mentally impaired at the time. That's all that the instruction says you have to do, is use those words. It never, ever defines it. And you have to define it, or it's got absolutely no teeth. And perhaps that was the situation in this case. And it's something that is all too often used as a defense that needs something more. When you take it to the next level and you talk about criminal responsibility, you don't just talk about lack of criminal responsibility and allow the jury just to refer to the testimony of the psychiatrist or psychologist and rest on that. You tell them exactly what a lack of criminal responsibility is. With every defense, you tell the jury what the defense is and you define it. And that just has to be done when it comes to mental impairment. It's just an undefined term that needs some sort of clarification if it's going to have any legal significance to a jury.
Do you know when we first started using the term mental impairment? When we first started using the term mental impairment?
Well, not specifically, but I know that it goes back certainly early 80s. I know it was,
I mean, did it go back to the 19th century?
No.
you know what, I really...
It makes a difference, because if it's a more modern use, then it means something. And it means something other than criminal responsibility or insanity or whatever it is.
But I do know that it just can't be thrown out there by the defense. It has to be supported.
Right.
Now, if the court has any additional questions, I think the other two issues really speak for themselves, the summation, the Kozak, and then the 33E argument. Unless the court has any further questions, I would rest on my brief.
Thank you, Mr. Nyman.
Thanks.
Mr. Thomason, good morning.
Good morning, Your Honors. Robert Thompson on behalf of the Commonwealth. Your Honors, if I could just start with the mental impairment issue, as long as it's fresh in all our minds, Your Honor. The defense is suggesting here, one of the essential problems with what the defense is suggesting here today is that the jury should be told that mental impairment somehow reduces first-degree murder to second-degree murder or something less. But the law is well established here in the Commonwealth that intoxication or mental impairment is not any sort of affirmative defense like that. It is merely a factor that the jury can consider in terms of whether or not the defendant had framed the requisite intent. It is not a defense that needs to be defined for the juror. It is simply an evidentiary factor. Given that, the instruction that the judge gave here, that in considering any requisite knowledge, any requisite intent, deliberate premeditation, they could take into account and consider the impact of evidence of mental impairment was entirely appropriate and entirely within our law, Your Honor. In fact, as this court suggested in Commonwealth versus Waite, that any further definition, any further instructions on the court on how exactly the jury should weigh that mental impairment into their process, into the sufficiency of the evidence, would be intruding into the weighing and balancing process of evidence that is entirely the jury's province. It'd be inappropriate for the court to somehow define what exactly kind of mental problems might constitute a mental impairment, what exactly would or would not. The point is, that is what comes from the doctor, that is what comes from the evidence. The doctor here opined that this particular defendant's problems, in his opinion, create a problem of his ability to form a deliberate premeditation. He tried to explain why. The jury could assess that and determine whether or not it was credible. And they did not find it sufficiently credible here. That was all required. This court has from the time of Sires on, has quite clearly said that all that is required in this context is a simple instruction that says you may take such evidence into account on intent and deliberate premeditation. Your Honors, in terms of moving to the alleged undue restrictions on cross-examination, all that the judge did here is say that he could no longer use these photographs. When presented with the photographs, the witness on the first photograph said, "I don't see the braids that I did in that photograph." When presented with the second photograph, she said, "I don't recognize that to be the person." There was no basis from that point on, no authentication. There was no evidence that these photographs were a fair and accurate representation of the braiding that this witness did at the time in order for them to be pertinent. Without that foundational showing, the judge's restriction on the cross-examination was absolutely correct.
But are you suggesting they couldn't have been admitted into evidence? It was certainly a foundation-based. You could have admitted into evidence.
I'm not suggesting they could not have been admitted at all. I was about to suggest that if the defendant wanted to show, to impeach this witness, that this was indeed a fair and accurate representation of the braiding that was done, he could have tried to do so through another witness. He never did. There was no restriction on any such attempt at all.
How would he do that? I mean, realistically, they were a fair and accurate reflection of what the victim looked like during the course of the autopsy.
At the end of the autopsy or during the course of the autopsy.
And the autopsy occurred how long after the death?
I don't know exactly how long, certainly in a few hours, and certainly after some hospitalization and attempted treatment.
Isn't it I mean, couldn't the jury infer that there was no undoing of the braiding and then make whatever inferences they thought to be appropriate?
I don't know how you could infer that, Your Honor. The body's been moved, it's gone all over. There's no evidence that would indicate that braiding has any kind of particular permanency. There's no indication that she had finished the braiding process, that it had been closed off so that it would be secured. There's no evidence of that at all, Your Honor.
But then how can a defendant in this particular instance attempt to demonstrate that the braider did less braiding than she thought she did? I mean, this was the best evidence he had of what the person looked like, and he was using what he had to show that she had overestimated the amount of time between when she began braiding and when the shooting occurred.
Your Honor, if the photographs do not accurately represent the braiding, and he can't show that they do, then you can't just assume that they do.
But what you're asking for is impossible. I mean,
no, Your Honor. Here,
how could anybody say this is a fair and accurate representation of
there
the
are other
braiding?
witnesses at the scene, Your Honor. There are other people there at the table, at the chair, and in fact, at least Exhibit 12 was shown to one of the prior witnesses, and he indeed did suggest that he saw braiding in there that was done by the woman there. And so the argument, for a closing argument or whatever, it was already established that at least Exhibit 12 had, to some degree, was shown the braiding. Whether or not this witness agreed with that.
Mr. Thompson, you make a good argument. The only problem is that wasn't the basis of why the judge was rejecting it.
But
The
it is, Your Honor. She
Hold
said...
on. What the judge says is, you're suggesting she didn't do any blading. She didn't do any blading. I mean, she wasn't understanding the point of time.
What the judge said at the end is two things. One, all this is doing is upsetting the witnesses with graphic photos from the autopsy, and it's not
Because it's
accomplishing
very
anything.
upsetting to her, but she had misunderstood what the thrust of the cross-examination was.
Your Honor, that's you're focusing on one particular sentence in
No, I'm looking at, you're implying that she's making up this thing. You're trying to imply that she didn't braid hair.
And the judge denied that. The judge also said these are not a fair and representation of the victim's head or the braiding. She also said that, Your Honor.
Yeah, but the whole point of it is there's no dispute that she was braiding the hair. No dispute. She's missing the point. I mean, maybe she's not hearing it. That's possible.
Your Honor, that was the point that was coming across from the cross-examination because the witness did not see any braiding that she had done in those photographs. That was the only point that was coming across to the jury, and that was the only place that it could go. That point was discussed with trial counsel. Trial counsel did say, no, that's not the point I'm trying to make. I'm trying to get it to say that this has to do with the length of the braiding. But it doesn't go to the length of the braiding because this witness doesn't see the braiding in there. If she can't see the braiding, then for that purpose, the use of these photographs is not helping the defense or anybody else for that, and they need to be independently shown to be a fair and accurate representation of the braiding. At that point, then all he's accomplishing is upsetting the witness, and it's becoming more prejudicial, more disturbing than probative, and she has the discretion to exclude it on that basis, Your Honor. In fact, it should not be lost here that the witness did, in fact, agree that it would take 5 minutes to complete a full braid. She had not completed a full braid, so it must have taken much less than that. And in terms of on redirect, it was made quite clear that rather than the 15 minutes she said in direct, that it could have been as little as 5 minutes. This was not a critical issue for the defense, Your Honor. There was no dispute that the defendant walked away from the scene. He was gone from some period of time, and then he returned with a gun. This was cumulative evidence. The prior witness who was there said he walked down to the corner, around the corner, and then came back. The defendant himself said in one point that he walked over to the car, got the gun, and came back. And the other one, another time in one of his statements, is that he walked down to the corner and obtained the gun and made up his mind and came back. There was no question that he did indeed leave the scene for some period of time. And whether it was 2 minutes or 15 minutes is essentially not an important point on deliberate premeditation. That the walking away and grabbing a gun and returning is absolutely sufficient evidence of deliberate premeditation, as this court noted in Commonwealth versus Coleman, which was where the defendant walked away from a fight to a car, picked it up, he was followed by the victim, he turned right around and shot the victim, and that was sufficient evidence of deliberate premeditation because, again, he left and did it. The length of time was simply not a critical issue and was cumulative of other evidence in any event. Your Honor, in terms of the self-defense, there was evidence that the defendant had possessed a gun at some earlier points. There was no evidence that the victim, if I said defendant just then, I meant the victim. There was no evidence that anyone thought that the victim, when the defendant returned, that the victim was in possession of a gun at that time. That didn't come from the doctor, that didn't come from the defendant, that didn't come from anyone. At the time, the defendant returns with a gun, and has, from the doctor's testimony, has that physical exchange of punches with the victim. There's no evidence that would support a reasonable or subjective belief that he was in imminent danger of serious bodily harm or death that would justify a self-defense destruction in this circumstances. Again, also when the evidence is that he walked away and then returned to confront the victim possessing a gun, there's no evidence that would support a conclusion that he had used all available means to avoid physical combat. So that the judge was absolutely correct in saying that self-defense was not appropriate and not wanted, did not want instruction in this case. Your Honors, I would rest on my brief on the other issues as well, unless the court has any questions. And
Thank you, Mr. Thompson.
thank you.